Okay, we invite the applicant to the podium.
Thank you, Madam Mayor. For the record, Mark Watts with the law firm of Cobb Cole. My new address is 231 North Woodland Boulevard, DeLand, Florida. I'm nervous I was not going to get that right. And I'm here on behalf of I4 Automobile LLC and Brendan Hurley, the owner of that corporation or that limited liability company. As City Attorney just explained to you, we're here on second reading. I'm going to go through really a lot of the same things we talked about on first reading back in January about this, and then open up to any questions you might have. So, Becky, if we can go to the first one. Again, there's several things we'll be talking about tonight. I'm going to start out just talking about that first item on the list, talking about the second and final reading for the annexation. So if we can go to the next slide. You have in your staff report the map showing the property that we've petitioned to annex into the city of Lake Helen. The criteria for voluntary annexation is on the screen in front of you from Section 171.044 of the Florida statutes. We are, again, the owner of the property has a right to, if the property is contiguous to a municipality and the request is reasonably compact, we can petition the government of the adjacent municipality to annex in. There's a caveat to that. We can't create enclaves. We're going to talk about that in just a minute, and I know that that's been a particular topic that some people have been curious about recently as well. So if we can go to the next slide. 171.031, subsection 11, defines contiguity. It means that a substantial part of a boundary of the territory sought to be annexed by a municipality is coterminous with a part of the boundary of the municipality. The separation of territory by public right-of-ways or parks and roads and things of that nature doesn't necessarily break that contiguity. Here, we don't really have that issue. Your original, I think it's the 1888 boundary of the city of Lake Helen is actually adjacent to right around 1,000 linear feet of the eastern boundary of our client's property. So we feel very confident that we meet the definition under the statute and the case law that's interpreted it, that we are contiguous to the city of Lake Helen. Florida courts have further looked at contiguity and interpreted what it means. When used in the context of municipal annexation, contiguous has been defined as touching or adjoining in a reasonably substantial manner. Your presentation was great tonight. I think it showed, kind of how that machination works. And you can see where our property, the property that's subject to the application, kind of fits into that mix. So again, we're confident that we meet the criteria that we be contiguous. We can go to the next slide. Thank you. Just for your reference, there's the map. The green area is the property that the application applies to. The yellow area to the right on the map is the existing municipal boundaries for the city of Lake Helen. The blue area north is land, and the white area to the south is the remaining unincorporated areas. As I noted, that yellow boundary has been the city of Lake Helen boundary since 1888 when the city was incorporated. Becky, if we can go to the next slide. Reasonably compact. According to the statutory definition, compactness means the concentration of a piece of property in a single area and precludes any action that would create enclaves, pockets, or fingers in serpentine patterns. The term reasonably compact, is intended to prevent kind of that snaking pattern or the complete surrounding of a parcel by a municipality, by another or by unincorporated area by a municipality, kind of cutting off what their choices are and making provision of services generally inefficient. We can go to the next slide. All right, and that term, of course, also has been looked at in the courts. This is the County of Volusia versus City of Deltona case. City and owners attempted to shoestring annexation by using a narrow corridor to connect municipalities to an outlying non-contiguous area that desired to annex. Such annexations defeat the basic concept of municipal corporations of unity and compactness. It's probably a little hard to look at that language and then think back to the maps that we saw a little bit ago, but there are some things like that have been permitted over time, and that's kind of a common pattern that you see. I don't think it's the pattern that we have here, again, with the substantial amount of the boundary that's contiguous to the city of Lake Helen. So again, we're confident that we meet that test. Becky, if we can go to the next one. Okay. Did we go back? Forward one more. Okay.
This is the next
Good. Looks like I put that one in there twice. Let me follow along here.
enclaves.
Enclaves. There we go. All right. Now, as I noted in the statutory definition, one of the things that is prohibited when you're doing voluntary annexation is creating an enclave. So I've provided the definition from the statute of what is an enclave: any unincorporated, improved, or developed area that is enclosed within and bounded on all sides by a single municipality. This is relevant because we do have, there's two parcels to the north of our parcel that are still in the county. It's interesting when when you look at that piece of property right now, that property has two choices. That property can annex into the city of DeLand, or it can remain in an unincorporated area. One of the interesting things that I think, one of the interesting opportunities that's created by the annexation that we've proposed, again, we don't meet the statutory description of an enclave because we're not surrounding it by one municipality. We're actually providing a second option. The owner of that property, after this annexation is approved, would have the option of staying in unincorporated Volusia County, annexing into the city of DeLand, or annexing into the city of Lake Helen. So we've actually, I think if you think about the general idea of enclaves and what that's intended to do, you're actually increasing the choices that property owner has here. You're not putting them in any worse position than they are now. You're increasing the choices with regard to the communities they can choose to join in the future. All right, we can go to the next one. This kind of shows you the area, and I think the little triangular piece, and it looks like that map actually picks up a portion of the top corner there of the green should actually be white as well. That's still an unincorporated area. But that's the area that I'm talking about. Again, if you think about that statutory definition, it can't be surrounded by a single municipality. Here you have two municipalities would be the result, so it doesn't meet that definition of enclave. So based on that, the next slide. Your staff reviewed, you have Fred Milch from the East Central Florida Regional Planning Council, reviewed our application on behalf of the city and concluded that we do meet the criteria for voluntary annexation under 171.044. I'll stop there and see if anybody has any questions. And I did neglect, Brendan's going to kick me for this, he wanted to say something before we got started tonight too, so I would like to ask him to come up and make a couple of statements before we turn things back. But any questions before we...
Would his statements be relevant to the annexation or more to the Automall application, PD?
I think they're relevant to the general, they're general statements about the application process.
All right.
And some of the other characterizations that have been out there. So, any questions?
Any questions?
Yeah.
No.
Okay. Brendan, you want to come up and...
Well, good evening, Madam Mayor and Commissioners and staff and the public. I'm happy to be here, and thanks for the welcome that I've received so far. I feel it's necessary to make some clarifications because I believe that there's been some vilifications that need to be addressed. For some reason, the City of DeLand has painted a picture that they've been excluded from communications with the city of Lake Helen, and I've also been pillared and abused by this. But the blunt fact of the matter is that the I-4 Automall's process has been no secret all the way back to 2014, and we've had meetings with the city of DeLand on numerous occasions and others, of course, all the way back to 2015, and I was very taken aback, frankly, at Mayor Apgar's comments that they were blissfully unaware of everything when I met with them in September, myself, along with my attorneys and also with the city attorney, and we discussed the very subject of annexation. And the discussion at the time would basically put the bathroom in Lake Helen and the toilet in DeLand because of the intersection of the buildings, which was actually quite a ludicrous proposition. So it was not a surprise in any way, shape, or form that this discussion would go forward. I also want to state that I talk to businessmen and businesswomen in DeLand on a regular basis, and I can tell you that DeLand is not a business-friendly city. It's quite the opposite. I've talked to lawyers, I've talked to merchants, I've talked to shop owners, salon owners, restaurant owners, banks, and they all tell you the same story, that DeLand is not a city that is user-friendly for businesses, and that's unfortunate, because it's a great town. I've been there since 1991, raised my 4 daughters there. My business has been very successful, to which I'm very grateful to the community for, but I do not believe that the citizenry of DeLand is being aptly represented in this action. I think it's basically a mission, a crusade, if you will, by a number of people in senior management, the mayor particularly, in the city of DeLand, and I think that's an unfortunate situation. And I apologize that it's caused some people in the city of Lake Helen to be painted in a light that's absolutely not true. Thank you.
Thank you.
And Madam Mayor, if I can just add, we did, there was a meeting on Monday night that the City of DeLand asked us to come to and present some conditions that we were willing to look at that I'll get into in the next item. And one of the things that I corrected, I think, for the record of that meeting, and I know that you all have taken some heat over the perception of how this all has played out from a timeline standpoint. And one of the things that I reminded the mayor and commission in DeLand about was that a year ago this month, your city administrator attended a meeting with myself and our client and our consultants and the City of DeLand staff. And the purpose of that meeting was to talk about annexation of the property, to talk about the concept of dividing the property, because we do have buildings that are proposed in the Automall footprint that are bisected by the jurisdictional lines. And so we met with the intent of suggesting, a joint PUD to be processed by both cities, to go through that process and deal with things like interlocal agreements and joint planning areas, to deal with utilities and provision of services and things of that nature. And for one reason or another, I won't get into right now, at that time, we didn't get a whole lot of receptiveness to that conversation. And so the decision at that point was proceed with the county and deal with the annexation questions and everything else later. And we got to the county, and ultimately what the county said was, well, you're surrounded by 2 cities. Why, this really should be something that's dealt with by the cities. And so that's how we ended up here. But I think it's fair for you, from a public standpoint, for us to kind of put that on the record that, where this conversation started well over a year ago, but where the particular application, discussion started in April of last year, it was with, the intent of, let's do this. Let's do this with a joint agreement. Let's do this with the interlocal agreements and the JPAs that are now being requested again. So I think that's just, relevant for you to have in your mind tonight as well. Thank you.
Okay, thank you.